Good morning to my colleagues, the members of the Information Regulator, the CEO, the executives, and the stakeholders who are here today. I would like to acknowledge the media, colleagues, and members of the public who are joining us online. A very good morning to you all. We meet today during the month which we recognize as the Access to Information Month, which was known as the Right to Know Month. UNESCO has proclaimed the 28th of September as the International Day for Universal Access to Information, known as IDY. This day is observed annually to promote awareness about the right of access to information and assess progress made in promoting this right. In our country, the Promotion of Access to Information Act, known as PAIA, has been the catalyst for promoting transparency, openness, and good governance among public and private bodies for the past 23 years. We meet here today following our last meeting in March 2024, where we gave progress on our work in general, the cases we have dealt with, those we had resolved, and the high-level cases that were in the pipeline. We had a few matters outstanding, which we have now closed. Other matters are more complex, but a lot of progress has been made on these as well. We will be zooming a little bit more into the matters related to PAIA, but we will also provide some insight into POPIA cases. Let's start with the high-profile matters in PAIA. We have conducted investigations related to PAIA as a result of complaint lodged with us by organized structures and individual members of the public following the PAIA request to public and private bodies for access to certain records held by them. Some matters were resolved through mediation and settlement, while others needed us to issue enforcement notices. The following matters, among others, are the examples of why access to information is a human right that must be respected and promoted. We'll start with the SSA case, State Security Agency. On the 2nd of August 2024, we issued an enforcement notice to the State Security Agency known as SSA, directing it to release records following a complaint lodged with the regulator. The matter emanated from a PAIA request to SSA by an investigative journalist from the Daily Maverick Media House in June 2022. The PAIA request was for access to records on SSA's expenditure in the 2015 to 2019 financial years for services rendered to it by the African News Agency, including detailed description of all the goods and services the SSA procured from the agency, as well as proof of deliverables thereof. SSA did not respond to the request as required by law. SSA lack of response resulted in it being interpreted as a deemed refusal in terms of PAIA. The SSA attended to the matter after the prescribed time frame when it issued a refusal to grant access to the records, a response that was also deemed too late. Following extensive investigation and consideration of the matter by the Enforcement Committee, the regulator issued an enforcement notice in which it directed SSA to disclose the records requested by the complainant. The regulator found, among others, that SSA had failed to prove that the disclosure of the records could reasonably impede or result in a miscarriage of justice and reveal the identity of a confidential source of information in relation to an ongoing investigation on the matter related to the records being requested. SSA also failed to prove that the disclosure of the record would reasonably cause prejudice to the security of the country. SSA has decided to take the decision of the regulator on review in a court of law. And we'll deal with matters under investigation. First one is social media companies. Another matter we are currently investigating is the complaint made against social media companies X, formerly known as Twitter, Meta, and Google. The complainant has requested access to records relating to the classification of elections, risk assessment concerning South Africa's electoral integrity, and the application of global policies to local context within these three entities. The entity's refusal of access to the records is based on the general presumption that PAIA does not apply extraterritorially to these private bodies despite them conducting business in South Africa. The regulator accepted the complaints, and all three complaints are currently under investigation. Another complaint under investigation is that against the South African Revenue Services. A complaint was received against the decision of the South African Revenue Services Commissioner, where the complainant requested access to the former president individual tax returns for the tax year 2010 to 2018. The Commissioner of SARS refused access to the records. The investigation into this matter is at an advanced stage. Matters referred to the Enforcement Committee. The first one is Sibanye Stillwater Limited and the Department of Mineral Resources and Energy. We also received a complaint from a human rights organization based at the Wits School of Law against the mining company Sibanye Stillwater Limited. The complaint concerned a request for access to the annual compliance reports submitted by Sibanye Stillwater to the Department of Minerals and Resources and Energy in respect of social labor plans for the Eastern and Western platinum mines. The annual compliance report to which the complainant requested access related to progress on community projects that Sibanye Stillwater undertook to implement as part of their licensing requirement. The investigation report has been finalized and is being considered by the Enforcement Committee. Matters that we settled through mediation. Among the matters settled through mediation is a complaint we received from an investigative journalist who had written several articles about allegations of fraud and corruption at Gauteng hospitals. It is alleged that this had resulted in the assassination of the whistleblower, Ms. Babita Deokaran. The complaint lodged with the regulator was against the decision of the head of the Gauteng Department of Health to refuse access to records relating to scheduled payments to suppliers. Upon receipt of this complaint, the regulator invited the head of the Gauteng Department of Health for a settlement meeting, wherein they agreed to release the records requested. We look at submission of PAIA annual reports by private and public bodies. On the 25th of April 2024, we issued a notice calling on all public and private bodies to submit their PAIA annual reports for the year 2023 to 2024 as required in terms of Section 32 and Section 83(4) of PAIA. While we are still not satisfied by the low levels of submissions of these reports, we acknowledge the slight improvement compared to last year's submissions, and this may be attributed to the more efficient platform we created for this year's submission through the new e-service portal, which we developed and launched on 1 May 2024. Now, why is the submission of these reports fundamental? The importance of and purpose of these reports is to give an account on the number of requests for access received, access granted in full, access granted in terms of mandatory disclosure in the public interest, access refused, cases extended, and so on. The non-submission of these reports impede the regulator's ability to monitor the implementation of PAIA and the effectiveness to ensure that the right of access to information is fully exercised. Those who do not make submissions are infringing on these rights and contravening the law. We have noted the dismal submission of PAIA annual reports by public bodies. And this is a cause for concern because public bodies have an obligation to make the submission. Out of 853 public bodies, which comprise of national departments, provincial departments, local government structures, public entities, universities, TVET colleges, only 278 public bodies have submitted their annual reports to the regulator, and the overall compliance percentage is about 33%. When we look at the granular details of the compliance levels, we have a grave concern about the low reporting from local government, where out of 257 municipalities in the country, only 51 submitted their annual reports, which marks 20% compliance rate. This was closely followed by PFMA-listed public entities, where out of 371 entities, only 141 made submissions, resulting in a 38% compliance level. To a certain degree, we are pleased with the response by public bodies with regard to the submission of the PAIA annual reports. This demonstrates how they are giving effect to the constitutional right of access to any information. Although there was a good response from public bodies, political parties' submission was dismal, in that out of 52 registered political parties, only 11 submitted. 34,460 public bodies, including political parties, submitted their PAIA annual reports. There was a total of 122,198 requests for access received and 114,669 requests for access were granted in full. The regulator will soon submit proposals to Parliament for amendments to PAIA to provide for more stronger enforcement powers in terms of this act. The current provisions in PAIA are too mild, and we postulate that this may contribute to the laxness in the public body's compliance with the law. From April 2024, we conducted 30 PAIA compliance assessment against 3 social media platforms, Google, Facebook, and TikTok, and 17 law firms, including the following top 5 law firms, namely Bowmans, Clive Decker Hofmeyr, ENSA, ENS Africa, Weber Wenzel, and Vrexmans. Furthermore, we assessed Schedule 2 public entities such as the Development Bank of South Africa, Eskom, Telkom SA, and Transnet. We continue to advocate for the right of access to information on a global stage. And in this regard, the regulator plays a role at international level. Once again, in May 2024, we were re-elected as the chair and secretariat of the African Network of Information Commissions. Furthermore, the regulator serves on the executive committee of the International Conference for Information Commissioners, which is a global network of access to information oversight bodies. These roles do not only seek to serve as an advocacy platform, but also allow us to be instrumental in contributing to the realization of this right regionally and globally. We will be participating in UNESCO's International Conference to commemorate the International Day for Universal Access to Information in Ghana, which will be hosted by the government of Ghana from the 1st to the 2nd of October 2024. Furthermore, and similarly, in the effort to equip public bodies with mechanisms to comply with PAIA, we will host a seminar on the 27th of September in celebration of IDY at the University of Pretoria. The theme under which these engagements will be hosted is mainstreaming access to information and participation in the public sector. We'll now look at the work that we have done in POPIA. And in this regard, we'll share with you the enforcement notices that we have issued. On POPIA-related matters, since April this year, we have issued 4 enforcement notices. The first one against Blowback Municipality. This related to the unlawful processing of personal information of a former employee, where their personal information was exposed on the internet following her submission of declaration of interest containing their personal information. The second one is Lancet Laboratories, as a result of a compliance assessment which was necessitated by the number of security compromises that they had experienced. The company failed to comply with the notification requirements in terms of Section 22 of POPIA. The company had also failed to notify the data subject affected by the security compromise within a reasonable time. The third one is against the Electoral Commission, the IEC, as a result of a security compromise that occurred just before the 2024 national and provincial elections. This resulted in the candidate nomination lists of the African National Congress and the Umkhonto weSizwe Party being shared on various social media platforms. We initiated an assessment of their security systems on the safeguarding of personal information that they processed, and we found that they did not have adequate access control measures to protect the confidentiality of personal information in their possession. Furthermore, their Section 22 notification to notify the data subject consent was found to be inadequate. The last one is the WhatsApp LLC. This is a very long outstanding matter with numerous complexities. The regulator's preliminary assessment revealed, among others, that WhatsApp adopts different terms of service and privacy policies for users in the European region compared to users outside Europe, including South African users. The privacy safeguard for users in the European region appeared to be better than those for users in South Africa, even though the General Data Protection Regulation, the GDPR, and POPIA have similar standards and protections. The regulator deemed it appropriate to conduct a compliance assessment in terms of Section 89 of POPIA, given the insufficiency of WhatsApp privacy policy in demonstrating compliance with the provisions of POPIA. The regulator has issued an enforcement notice in which it directed WhatsApp LLC to comply with all the conditions for the lawful processing of personal information by updating their privacy policy, to conduct a personal information impact assessment, and to comply with the provision of PAIA insofar as it relates to its obligation to maintain the documentation of all processing operations it is responsible for. In this regard, the regulator dismissed WhatsApp's argument that PAIA does not apply to it as a social network which is extraterritorial. Regarding the ongoing high-profile investigations in POPIA, We are currently investigating another POPIA complaint on alleged interference with the protection of personal information of data subject by the South African Police Service. The personal information was processed by SAPS in the course of an investigation of a crime. The personal information was disseminated by the SAPS through WhatsApp messages. Due to the sensitivity of the case and considering that this is a similar matter where personal information was leaked, the regulator has embarked on an own initiative investigation into the alleged interference with personal information of data subjects. The matter has been referred to the Enforcement Committee. Now we come to direct marketing through unsolicited electronic communication. We have heard the plight of members of the public on the growing frustration because of spam calls as a result of direct marketing. We had reported earlier this year that we had drafted a guidance note on direct marketing, which seeks to guide public and private bodies on how to comply with POPIA when processing personal information of data subject for direct marketing other than by unsolicited electronic communication in terms of Section 11.3b of POPIA, and by unsolicited electronic communication in terms of Section 69, and also to empower data subjects to protect their rights. In June 2024, we shared the guidance note with stakeholders in the direct marketing organized structures and the big industry players who largely use direct marketing as part of their business practices. We are at the advanced final stage of considering their input, and on the 25th of September 2024, we will hold a stakeholder engagement on the final version of the guidance note ahead of its publication. Security compromises, we cannot stress enough our concerns with the increase in the number of security compromise incidents that have been reported to us since the coming into effect of the enforcement powers of the regulator in July 2021. Since the beginning of April 2024, we have received 980 security compromise notifications. This tells us that the public and private bodies may not have adequate organizational and technical measures to ensure the integrity and confidentiality of personal information in their possession or under their control. We have since ensured that in all compliance assessments that we conduct, we concentrate in the security safeguard measures that public and private bodies have put in place. Thank you for your attention and for your attendance, and we'll take questions.
Thank you very much, Chairperson. Can I just make a request again that when we are responding to the questions, if we could just lean in a bit on our microphones so that we can get a proper feed to our attendees online. We are now going to take questions, and we will just request that if you could introduce your organization, your media house, and then pose your question. We'll try to take the question in about a segment of 5 per round. So we will also acknowledge anyone online that may have a question to ask. We'll allow you to then unmute yourself and introduce yourself and ask the question. If you have a challenge with your mic, you can always type out in the chat. We can start to take questions in the room, then we'll go online. We have one colleague there. I just want to get to 5 hands if anyone else. 2, 3, and then do we have any questions online? Any hands online? Okay, if we don't for now, we'll start with the gentleman there. We'll come to my end, and then we'll end on that side with Isaac. Thank you. Sorry, can we get a microphone on that side, or you won't be audible, sir?
Good morning, everyone. My name is Tabiso Koba from Eyewitness News. Since you didn't get a lot of hands, I'll just take a bit of liberty by asking a couple of questions. My first question has to do with you mentioned that you're going to be appealing to Parliament about expanding the powers of this regulator because you believe that that's contributing to some of the lacks why people are not submitting their PAIA annual reports. What powers are you specifically going to be looking for in terms of enforcement, and maybe what are the loopholes do you see that is making a lot of organizations not being very compliant? And I think my second question also flows from the first one in terms of the actions that you've taken against the social media companies. We have seen in Brazil, they've banned Twitter. I don't know if that would be something that would be open to the information regulator, especially considering that from what I'm reading is that they are just basically ignoring any sort of enforcement and compliance. What actions are available to the information regulator to take against these very big social media houses? And then in terms of political parties, as you said here, that only 11 out of the 52 submitted their annual reports. How concerning it is that, especially when we're coming from the elections where there was obviously when parties were getting signatures, there was obviously some rumors that some people's signatures and ID numbers may have not been taken from them personally. So how concerning is it that a lot of political parties, especially coming after elections, are not complying with this? And my last question is just in terms of spam calls. I know this is being addressed here, but can you just maybe, I think in simple terms, just why is this happening? Why do people keep getting spam calls? And yeah, I just want to know just why it's happening. I understand that it's going to be addressed, but I just want to understand why does it keep happening? Thank you.
Thank you. We'll come to you and then we'll go to that end.
Hello, everyone. My name is Emeric Vincenot. I'm working with AFP, the French news agency. My question was close to one of the questions that was asked. Basically, what are the powers of the information regulator if any company, for example, let's take Meta and Google you spoke about, refuses to abide by the enforcement directive you gave them? Do you have any power to find them or shut them down? Or
Can you just repeat the media house you're from? Sorry.
I'm with AFP, Agence France Presse, the French news agency.
Good morning. My name is Isaac Menard from the South African National Editors Forum. On the proposals to Parliament for the amendment of PAIA, can you confirm if the information regulator will include the proposals made by civil society organizations on how PAIA should be reformed in terms of the report that was done a few years back on South Africa's compliance with the African Commission's guidelines on access to information in elections, as well as the African model law, particularly, for instance, to strengthen the proactive disclosure and to make it fit for purpose in the digital age in line of the African Declaration of Principles on Freedom of Expression and Access to Information, which would effectively mean that any information that the public or anybody else would require should be available proactively published online. So we would like to know if the proposals made a year or so ago have been incorporated into the proposals for reform of PAIA. Thank you.
Thank you very much, Chairperson. I'll hand over to you and the panel members, and we will then take another round after this one. Thank you.
I'm going to ask Ms. Nemasisi to respond to the first and the last question regarding amendment of PAIA, and how far is that process and what is it that we're trying to address. Are we looking into banning Twitter as it was done in Brazil? I don't think the regulator has those powers. If that is going to happen, it has to, it's the government that has to do so. But I think taking into consideration the importance of the right to freedom of expression and to the need to balance that right against other rights. I'm not speaking for government, but I think it will be difficult for the South African government that holds the right to freedom of expression so high to ban any social media platform. So I don't think we'll go there. Regarding the political parties, it is quite concerning, of course, particularly because some of those political parties that did not submit the reports are represented in parliament, and they are lawmakers. They have made the law, and one would have expected them to actually lead in ensuring compliance with PAIA. But I also have to add that in the third quarter of this year, we will be conducting PAIA compliance assessments by the provincial legislature and by parliament, looking at both the National Assembly and the National Council of Provinces. About the powers that we have, if our enforcement notices are not complied with, I'll give that to Advocate Wikanyo. Spam calls. This is our albatross, if I can put it that way. And the issue here, as we have said on a number of occasions, is how the direct marketing sector and other private bodies have interpreted the word electronic communication in POPIA. Their interpretation is that electronic communication does not apply to telephone calls. Therefore, that the requirement, the POPIA requirement, the stringent requirements for direct marketing through unsolicited electronic communication do not apply to telephone, so that people can just call you, to market goods to you. But we don't agree. We have done research and we have benchmarked with our sister organizations, and our firm view is that a telephone constitutes an electronic communication. Therefore, before you market goods to anyone through a telephone, the law requires that, one, you must have obtained the telephone numbers of the person that you intend to market to lawfully. You cannot buy their details. That's the first thing. The second requirement is that when you call that person, the first call that you make to them is to ask them if they consent to receiving direct marketing messages, and if so, how they want those messages to be communicated to them. Is it through SMS? Is it through email? And so forth. And thirdly, that they must be specific. They must tell you which goods or services they want to market to you. You must give consent first. only after you have given consent can they then send direct marketing messages to you. If you say no, then they shouldn't, and they must have a list of all the people who have said no, so that they do not contact them again. I think what is important is to note that the information regulator's view is not that direct marketing through a telephone cannot be done. That's not what we are saying. We are saying, yes, you can do direct marketing through spam calls, that is allowed, but ensure that in doing that, you comply with the provisions of POPIA. I think it's important to stress that message. So this one, as we're saying, we have received extensive input from the direct marketing sector and from other private sector stakeholders on this one. And on the 25th of September, we're going to gather in one room to deal with this matter. But we have taken a position on this. I think it's important to say that. So, and then we'll take it from there and we'll see what happens. Of course, we'll listen to them and hear their arguments, which they have put in writing, and we have responded to those arguments that they have put to us. So, from AFB, Powers of the Regulator, Advocate Buitanyo, and from SANEF, Amendment to PAIA, Mr. Namasisi.
Thank you very much, Chairperson. Maybe just to then say that where the Information Regulator has issued an enforcement notice, there would be certain directives in that enforcement notice, and the responsible party would then be afforded a particular time frame within which to comply with those directives from the Information Regulator. And if the responsible party does not then comply with those directives, after the period has then expired, we will then, as the Information Regulator, we may issue an infringement notice. You would know that from the Act that the infringement notice, in terms of the infringement notice, we can impose a fine of up to 10 million or a period of imprisonment of 10 years as a maximum. That addresses the issue of the infringement notice. I'll hand over to Mr. Namasisi to respond.
Thank you so much, Chairperson. There was a question about what powers do we have under the promotion of access to information that require, and what are the loopholes that we have identified that necessitated the requirement to amend the provision of PAIA. Firstly, PAIA should have been mirrored POPIA. I'll give an example with regard to conducting an assessment. Under POPIA, when you conduct an assessment, the assessment report is considered an enforcement notice. However, under PAIA, when you conduct an assessment, all the reports that we issue, we do not have enforcement power as the regulator to enforce non-compliance with that assessment report that we have issued. So that's the first aspect in terms of enforcement power that will require the PAIA to be amended so that the regulator can be effective insofar as compliance assessment is concerned. Again, if you look as well when to come to the enforcement power, when we issue enforcement notice, for us to enforce non-compliance with enforcement notice, we then have to go and rely on other security agencies like SAPS. And that obviously takes away the enforcement power of the regulator. What we're looking at is the powers in terms of which we may have to impose certain penalties as well for non-compliance. And that will ensure that the regulator is effective. So those are some of the aspects that we're looking at in terms of amendment of PAIA to ensure that the regulator's power are effective and we're able to make follow-ups. Lastly, we have, for example, we have indicated now that majority of public bodies did not comply with the requirement to submit annual report to the Information Regulator and some of the political parties. We do not have enforcement powers in terms of what is it that we should do against those bodies. And that's why we need to amend PAIA as well, so that those who do not comply with the legislation would then have to take action against them. At this stage, there's nothing much that we can do. And those are the things that we have identified that requires amendment of PAIA. There was another question regarding whether we have we're going to consider in amending the PAIA, the proposal from civil society organization. Indeed, the information regulator work closely with the civil society organization, and all the proposal that has been made will definitely be considered by the information regulator before the proposed amendment are submitted to the Department of Justice for further processing. The same way that we're going to have a stakeholder engagement on direct marketing on the 27th of in September now, we're going to follow the same process where the civil society organization will be invited so that we can engage before the final decision is taken as to what amendments will be made. Thank you, Chair.
Thank you very much. We're going to look at some of the questions that we have online. If I could just ask Tsecho to read out some of the questions that we have.
Thank you, Chair. The first question that we have is from Miles from My Broadband. His question is regarding the regulation that the first call from a telemarketer must request consent to market to the individual. Assuming the recipient doesn't answer the call requesting consent, how many times can a telemarketer attempt to contact a person to request consent? Okay, thank you. The second one is from Petro. Petro asks, regarding the security compromise notifications received since April, can you provide more information on the types of breaches involved? Were they primarily cybersecurity related, or did they include other forms of breaches as well? Yeah. Yes, that's all. Thank you.
Do we have any other questions? Yes, we have Cindy over there. And anyone else? We have the colleague there and for a follow-up. Okay, we're feeling generous today. I'll give you the follow-up, then we'll take it from there. Thank you. And then we'll end with you. Thank you.
Good
we have the mic there.
Yes.
Thank you.
Thanks, Nomsam. Good morning, everyone. Simnikiwe from IT Web here. Advocate, you mentioned, you spoke about the concern around the increase in the terms of the cyber security incidents. And I want to go back to an update on the DOJ. And the reason I'm asking this is because they also suffered another cyber security incident in May. What's the update around that? And did the information regulator receive notification from the DOJ around this latest, their latest cyber breach or cyber security incident that they encountered? And just an update on the fine. What's happening over there? Thank you.
Okay, thank you very much. My name is Obopian Huitione. I'm not from any media house. I'm just a researcher with keen interest in this subject. The chair, you mentioned something around that the privacy safeguards for users in European region appears to be better than those for the users in South Africa. What learnings can we take from the GDPR and also international best practice to incorporate in the POPIA to look at strengthening our act as well? Thank you very much.
We can take your follow-up, sir. Oh, you fine? Okay.
Yes, thank you. I'm not sure I understand you two gentlemen very well. For me, I heard a contradiction in what you were saying. I heard that you had power to impose some fines and jail times. And your colleague to your right was saying that you were asking for some amendments to give the proper power of sanctions, as far as I understand, to the information regulator. So could you explain this? Sorry, maybe the chairperson or you can tell me, do we have a time frame on the notice that was sent to WhatsApp for them to respond? And what's next in a concrete way, in a specific way, what's next if they don't comply or if they refuse to respond to your enforcement notice? Thank you.
All right, thank you. Over to you, Chair.
the last question on WhatsApp. What's POPIA versus PAIA? I think Ms. Nemasisi will take that to just say what is the difference, because we administer two pieces of legislation which are different. So, but they will explain. Time frames regarding WhatsApp. Advocate Wikanyo, will you take that? Can you also take Pedro's question on security compromises and types of breaches? Also, the DOJ matter, Advocate Wikanyo, can you take that? Regarding a question from my broadband, POPIA does not prescribe the number of times that you can call a data subject for the purpose of obtaining their consent. If they don't respond to your call, because nothing prevents them from calling you until they find you. But what is important is that that first call should be for obtaining your consent. I think members of the public have to be educated on that. That when they call and say, well, want to insurance or whatever, you say your call, the first call, you have not asked for my consent whether I want to receive this message or not. So that's how the scheme of the act. I think the problem is that, and not only with telemarketing, but even with SMS, even with direct marketing through email, try to click on unsubscribe. I tell you, the following day you'll receive the same message, even if you have unsubscribed. So it means the system is not working. Even if we are told that there is a database of people who have unsubscribed, but I have personal experience of clicking unsubscribe, but all the time I keep on receiving messages from companies that I'm supposed to have unsubscribed to. Is there anything that we can learn from the GDPR? Not quite. POPIA is fashioned along the GDPR lines. That is why we were surprised why, if the two legislations are the same, why are the users in South Africa treated differently from users in Europe? But what we can learn and what we should, and what we're discussing is that in terms of the GDPR, once there is non-compliance, a fine is levied immediately, pay a fine. With us, there is a grace period, and this is where I think the problem is, because when we issue our enforcement notice as the regulator, we give the responsible party a time period within which they must comply. If they don't comply within that time period, we then issue a fine. So what we see is that in all these security compromises that we are investigating and the assessments, the compliance assessments, we give the time frame for compliance, and in 99.9%, those people will comply. So we can't fine them. But then they suffer another data breach. So I think the law has to be amended, and it has to be like the GDPR. We have, for now, we were still learning. It was a new piece of legislation. We were still trying to, see how it works. But we've done that in the past 7 years, 8 years. And the time has come for us to be firm, and this is a proposal that we'll be making to Parliament, so that you then violate the law, we investigate or assess you. If we find that indeed you have violated POPIA, we must fine you immediately. And I think once we start doing that, once the law provides that, I tell you, most private and public bodies will sit up and they will ensure that they comply. Mr. Nemasisi, Advocate Bukai.
Thank you, Chair. There was a question about possible contradiction about the earlier statement. But as Chair has indicated, we perform dual mandate. So you've got the promotion of access to information, which legislation is more than 23 years old so far. So we came in when the legislation had already been passed. And the protection of personal information was passed later on in 2013. And it has got better provision, although we still need to amend, as the chairperson has highlighted, in terms of enforcement mechanism compared to PAIA, which is a very old legislation. And I think that's why even the civil society organization have made those submissions to the regulator to say, please consider amending the PAIA. It's outdated, and some of the measures that are there were put in before the regulator was established. And that's why you don't have sufficient enforcement mechanism. So that's the difference between the two. So POPIA has got much better enforcement mechanism, but PAIA does not have, although we do have to amend both legislation. Thank you, Chair.
Thank you very much. In relation to the question on WhatsApp, I think the chairperson of the regulator has already stated the fact that WhatsApp really adopts different terms and the privacy policy for the European countries than those in South Africa. So essentially what that means is that there's a better protection that is given to data subject in the European countries than in South Africa. So in the enforcement notice, what we then said as the regulator is that WhatsApp was ordered to amend its privacy policy to ensure that it offers the same levels of protection that is afforded to those countries, to those data subjects that are in the other countries. And we then afforded them a period of 60 days within which to comply. There was a question on cybersecurity as to whether, on security compromises, as to whether the class of security compromises that we receive are only confined to cybersecurity. No, they're not confined only to cybersecurity. We also receive other matters, other security compromises that relate to personal information, for instance, that is sent to wrong recipients. In the media statement that the chairperson was reading, there's a matter of Lancet Laboratories, if I was to take that as an example, where personal information was sent to wrong recipients. So the class is not only confined to the class of security compromises. With regard to the Department of Justice, we had to, as the information regulator, write to DOJ to establish whether there was personal information that had been compromised as a result of the security compromise. And the response of DOJ was that there was no the personal information that has been compromised. We're still ongoing insofar as our investigation is concerned. This is a matter that we're still engaging the Department of Justice on, and we had a stage where we will make a determination of whether or not, on the basis of the information that we will receive, we will conduct an investigation or we'll conduct an assessment on the Department of Justice emanating from this. You would remember that this was as a result of the security compromise in the area of in the Guardian Fund account. So we are continuing with our engagement with the Department of Justice with regard to this. I don't know whether there's any other question that I've missed, Chairperson.
Regarding the previous one, the fine, the infringement, they decide, we fined them 5 million rands, and they've decided to take us on.
Oh, yes. Insofar as the first matter relating to the Department of Justice is concerned, we had issued an enforcement notice, and because the Department of Justice did not take any corrective measures as contained in the enforcement notice, we then went to the next stage, which is the infringement notice stage, and we imposed an administrative fine of 5 million. And the Department of Justice has decided to take this matter on appeal and on review in the High Court. Thank you very much, Chairperson.
Thank you very much. As we bring the session to an end, I will give you an opportunity, Isaac. I just have one question from our YouTube channel. There's a question from Wayne Slabbert, who asks, will there be amendments made to POPIA 2013 with respect to having the right to be forgotten related to spam, since DMASA only removes you for a period of 3 years? I just wanted to make sure that we are inclusive in terms of our participants online, and then I will be closing it off with you, Isaac. And then we have one more follow-up, and we'll bring this briefing to a close. Thank you.
Thank you. On the issue of social media companies and the current investigation, what is the status of the complaints regarding TikTok on exactly the same issues? And secondly, I wonder if you can just explain a bit this issue of jurisdiction. So most of these companies are so dominant in the market that they effectively establish themselves as public utilities. The same issue that's been raised in the Competition Commission's inquiry. So how is it possible that a company that plays such a big role, not only from a commercial perspective, but also in terms of access to information, how is it possible that they can say that they they challenge the jurisdiction of the Information Regulator? Thank you.
I'm going to do this. On the question of the right to be forgotten, we're going to deal with it historically, the historical context. And with that, I'll give Ms. Tilly to give the historical context when POPIA was drafted, why the right to be forgotten was not included in POPIA. And then I will then ask one of the executives, because they have already looked at some proposals for the amendment of POPIA. It hasn't come to us as members, but preliminarily, I don't know if you have looked at the right to be forgotten in the amendments that you have. Isaac, I'm weary for us to enter that debate because this matter is under investigation. And the issue of jurisdiction is the issue that has been raised preliminarily. Although in the WhatsApp matter, you must remember that it was an assessment, a compliance assessment. They raised the issue of the jurisdiction, but they also raised the issue of the applicability of PAIA to them. And we said POPIA applies to them, and we dealt with jurisdiction. But now, in the investigation that we are conducting, that issue has also been raised. And I'll ask, I don't know, it's Ms. Nemasisi, briefly without going into details, because this matter is still under investigation. And even with WhatsApp, we have sent the enforcement notice to them. We've given them the enforcement notice, and we have told them that we don't agree with their arguments on lack of jurisdiction. Of course, we don't know once they receive our enforcement. They have received it, but we don't know what is the next step that they will take. So we'll see.
Is TikTok not part of the list?
I don't know, because you see how it works. Maybe this is why some questions I refer to the executives. The way the system works, when there's an assessment or an investigation, it is conducted by the administration. If it is a POPIA assessment or investigation, after they have compiled a report, they then give it to the enforcement committee, which is a committee made up of outsiders and one member of the regulator. That enforcement committee then makes a recommendation to the regulator, to the five of us, except the one who will be sitting on the enforcement committee. Then we look at what the enforcement committee says. In 95% of cases, we have agreed with them. In 5%, we haven't agreed. And if we don't agree, we can change their finding, and we can also issue a different directive from theirs. So that's as far as POPIA is concerned. Insofar as PAIA is concerned, we said that we don't have similar enforcement powers as in POPIA. So an assessment reports of PAIA do not go to the enforcement committee because non-compliance with an assessment report does not attract any legal consequences. It's only investigation reports of PAIA that go to the enforcement committee and then they come to us. So because of that scheme, legislative scheme, there has to be sort of a Chinese wall, if I can put it that way, between the administration and us so that there's no conflict of interest. You know, when the matter comes to us, it must come cold. We must not have been involved at all in that matter. So that's why I always refer in some of these instances to the executives. But before you talk about the right to be forgotten, let me give you that opportunity to say, yeah, historically, why was this not included in POPIA?
Thank you, Chair. When POPIA was being drafted and towards the end of the process, that was the point at which the right to be forgotten was being discussed in Europe, and particularly in relation to updates to the GDPR. And we found ourselves in a slightly different situation because in South Africa, you have the Right to Information. And in terms of the way our Access to Information Act is drafted, you have the right to private information held by private bodies, which is a very unusual thing internationally and creates a situation where you have to weigh up the right to privacy as against the right to information. Just technically, even in Europe, what you're really doing, and you say the right to be forgotten, it's not that the internet forgets who you are. It's simply that the bigger search engines agree not to point searches towards the information that is there about you. And we felt it was really too early in the development of the right to be forgotten for us to be taking it on board, and that's something we would consider at a later stage. And you know, I think those issues are potentially on the table. I don't think anybody's raised it with us directly, but you know, that is something that I think the theory was that we would return to it when it was clearer, and also how it would fit with our transparency regime. And the regulator, as we've said, deals with both. So we theoretically are the people who should be able to find the balance between the two.
I don't know whether in the proposed amendments, but we must make it clear these are proposals because we don't amend legislations, Parliament, through the Department of Justice. So if we make those proposals, they'll have to go to the Department of Justice.
Yeah, Chair, maybe just to come in and say the following, that I think since the coming into effect of the enforcement powers of the Information Regulator on the 1st of July 2021, and having conducted quite a number of assessments since then and certain investigations, it has become clear that we need, as a regulator, there are gaps within POPIA that we need to address. The chairperson also mentioned some of them relating to the imposition of fine when there's a contravention of POPIA. But we have looked at POPIA as a whole, Chair, and have identified a number of sections, which also includes the right to be forgotten. As Mr. Namasisi had said, and he has outlined the process, that in us effecting these amendments, we will extensively consult with different sectors, and so that we also get their inputs with regard to what they propose as amendments. So we have looked at it, Chair, but we have not obviously finalized it, and we will go to the different sectors for them to provide us with inputs. There was a question, and maybe Chair should just draw the distinction between the various entities that are owned by Facebook Incorporated. As we would know, Facebook Incorporated is based in Menlo Park in California, and it has quite a number of different legal entities. It has Instagram, it has also WhatsApp as a separate legal entity. So when we conducted our assessment, for instance, as POPIA, our assessment was conducted only on WhatsApp as a separate legal entity and not on the other legal entities that are under Facebook Incorporated. I felt that I should just provide clarity with regard to that.
I'm not aware, Chair, about the complaint against TikTok under PAIA. It's something that I'll have to check with my colleagues whether there's any complaint against PAIA. What I'm aware of is that we did conduct compliance assessment against TikTok. And there was no objection about our jurisdiction when we conduct assessment against X, against Google. We conduct assessment against those ones. There was a question about the status of our investigation regarding those social media companies, X, which is formerly Twitter, Meta, and Google. There was an issue, which I'll link this, about the jurisdiction of the Information Regulator insofar as this international social media company is concerned. And the issue of jurisdiction is that it can't be, and that's the position of the regulator, it can't be that South Africa has got legislation, and this international body provides services in South Africa, and they do not want to abide by South African legislation. It cannot be. And that's the position that we've taken as the regulator, that if you are providing services in South Africa, you must abide by South African legislation. And we normally find this in line with what the chairs indicated with regard to the other POPIA-related matters, that when you come to South Africa, this international body will then say they're not abiding by, but let them go to another countries where they do not have territorial jurisdiction. They abide with those legislation. And that's the principle that we're applying as well here. So when we receive this complaint in terms of status, we assess firstly whether the complainant has complied with all the procedural requirements. And that we found that they've complied so far as the complaint to be lodged with the regulator. The second aspect was the issue of jurisdiction. Before we can investigate, we need to check whether we've got jurisdiction. It was challenged, and we conclude that we do have sufficient jurisdiction to investigate complaints against these international bodies insofar as the promotion of access to information is concerned. And as I indicated, based on the fact that they are providing services in the Republic, and we've got legislation that they need to comply with. Thank you, Chair.
Thank you so much. We apologize, Simnike, we acknowledged you before. We'll just give you the absolute last question to ask, if you'd allow, Chair.
Okay, thank you. This is just a follow-up on the grace period, Chair. Just to find out, are you looking at then approaching Parliament to ask them to amend the law in terms of scrapping the whole 60 days? And when will, like in terms of time frames, when would the Information Regulator be looking to go ahead with that going forward?
Well, we determine the time frames. The time frame is not stipulated in the law. So when we issue an enforcement notice, we look at the facts of that particular case and determine whether they should comply within 60 days. Sometimes it's 90 days, and so forth. I mean, as I said, we can't have time frames because we're not lawmakers. And we don't even know when we make these proposals to lawmakers, what will their attitude be. All that we can do is to say to them, these are the loopholes that we have found, and we propose that the law should be amended. And of course, because the amendments have already been identified, the loopholes have already been identified, it's going to happen maybe before the end of the financial year. I'm looking at my boss, the CEO, because these things have financial implications. If we have stakeholder engagement, how many stakeholders can we accommodate? Just to give you an example, just with the direct marketing sector, we now have about 200 stakeholders who want to come to our consultation, and I mean we can't afford to have 200 people. So, but I think it will happen. I'm looking at you. Do you think these amendments will have the stakeholder engagement before the end of the financial year? I don't know what the schedule is.
Thank you very much. I think it's a planning issue, and we have started with the planning season in the regulator in September. So I think we'll go into the new financial year to determine that through our APP and our AOP. So it will go into our plans. So we haven't as yet determined the period. Thank you, Chair.
Beauty of having the CEO, you see, the chairperson will just say before the end of the financial year, and the CEO say, but we have to plan for it and have a budget for it before we can do it. Thank you for that.
Thank you very much, Chair, to all the members, as well as CEO and the executives. But mostly, thank you so much for all your participation, the media houses here, and everyone watching online. We'd like to declare this media briefing closed. Thank you very much.